leads to a result which is manifestly observed or unresolved. So we only have two provisions here, Article 31 and Article 32, and those two provisions of the Vienna Convention on the Law of Treaties are the international regime for the interpretation of treaties. Okay? So the most fundamental rule is expressed here in Article 31.1. That's the very basic provision regarding the interpretation of treaty. A treaty shall be interpreted in good faith, in accordance with the ordinary meaning to be given to the terms, in the context and in the light of the object and purpose of the treaty. Okay? So this is the very basic provisions regarding the interpretation of treaties. But interpretation of treaty can be presented referring to three schools, what we could call schools of interpretation: the textualist, the intentionalist, and the theological school of interpretation, or perception or opinion on interpretation. And we try to explain each one of these presentation on international interpretation of treaties or interpretation of international treaties. So what does it mean? What does it mean? The textualist approach to of interpretation, or the textualist school on of treaty interpretation. What could that mean? What could it mean to refer to the textualist approach of interpretation?
Totally based on the written text.
Yeah, it means that you have to rely basically on the words used by the drafters of the treaty. Well, you have to identify you have to refer to the ordinary meaning of the words used in the provision. So we have this here. So the textualist approach is used within the Vienna Convention on the Law of Treaties, when in Article 31 you have the reference to in accordance with the ordinary meaning to be given to the terms of treaty. Okay? So first, you identify the ordinary meaning of the words used in the treaty, in the provision that you have to interpret. So the textualist approach is the most basic one, in that a word means what it means. Okay? So there is an ordinary meaning of the word, and we have to, the interpreter has to interpret the provision by referring to the ordinary meaning of the words used in the provision. Okay? That's the most basic way to interpret the provision. The second one, the intentionalist. What could that mean?
Are the intention of the treaty maker?
Yeah, the intention of the treaty treaty makers or the drafters of the treaty. Well, can we say that this is accepted by the Vienna Convention on the Law of Treaties? Or can we identify in the Vienna Convention on the Law of Treaties one provision regarding interpretation that could be seen as the manifestation of recognition of the intentionalist approach to interpretation? Well, can you see that on this provision? The answer is no. Stop reading. Can we see that here? Can we see the intentionalist approach here?
Full special meaning that should be given to the term established so intended.
Yeah, in a way, in Article 31.4, there is a clear reference to the intention of the parties. The intention of the parties not to give to a term its ordinary meaning, but to use the term with a special meaning. So you will have to identify what was the intention, what was the will of the negotiators of the treaty, of the states participating in the negotiation of treaty. So that's one point. And can we find the intentionalist approach in Article 32?
Determine the meaning.
Well, to determine the meaning of the provision is the operation of interpreting the provision.
Preparatory work.
Yeah, what is it, preparatory work?
The intention.
Yeah, the preparatory. You're right. Article 32 is a clear reference to the intentionalist approach of the interpretation of international treaties. So the intentionalist approach is endorsed by the Vienna Convention on the Law of Treaties in Article 32, when Article 32 makes a clear reference to the supplementary means of interpretation, including the preparatory work or the preparatory works of the treaty. What is it, the preparatory work of treaty or the preparatory works of a treaty? What does it mean that the individual or the tribunal that has to interpret the treaty, what does it mean that he may refer to or he may use supplementary means of interpretation such as the preparatory work of treaty? And why do we say that the preparatory work of the treaty can be used to identify the intention of the negotiators, the intention of the drafters of the treaty? What does it mean, preparatory work? Do you have any idea on that?
Piece of text that explains the purpose of the law or the treaty, including the debate between the parties for and against that law or treaties.
Yeah, it's just the documents that were used during the negotiation of the treaty. When you negotiate a treaty, of course, the negotiations are not all the same, but if you have a negotiation between two states, each one comes with some with a draft of the treaty, or with some propositions regarding the treaty that has to be negotiated. And of course, the negotiation is discussion between states or between the diplomats of the states. And if you want to identify what was the intention of the negotiators, you will refer to the preparatory works, the opinion that were expressed by the negotiators during the negotiation. So, by using the preparatory work of the treaty, you may identify what was the intention of the negotiators, what was the intention of the states involved in the negotiation. But the question is, how do international tribunals use the preparatory works? It's quite common to say that the preparatory works are not used as a priority mean of interpretation of an international treaty. Why can we say that the priority has not to be given to the preparatory works or to the supplementary means of interpretation? Why can we say that? Well, this is the priority, Article 31, and this is not the priority rule of interpretation, Article 32. So, why can we say that the textualist approach comes first in the Vienna Convention, and the intentionalist only comes second in the Vienna Convention? Why can we say that? Just reading Article 31 and Article 32, I can try to do that. Yeah, I don't know how to remove that. So this is the beginning of Article 31, and this is Article 32, just to see all on the same slide. So why can we say that this Article 31 comes first, and this Article 32 is only a secondary means of interpretation?
Because in general, word usually interpreted by usual meaning, like ordinary meaning.
But what? Or why can we say that just reading Article 31 and Article 32?
It is agreed and understood by states before it is binding already. In case that it can have like ambiguous meanings, so as a can option to that.
Yeah. And is it the only situation in which the secondary option will be used by the tribunal or the person in charge of the interpretation? Well, first, what is the justification in the Vienna Convention of what we've said? Priority to Article 31 and only use of Article 32 in certain circumstances. Why can we say that only by reading the Vienna Convention? Thank you. Okay. No, I'm just counting because there are some miracles sometimes. You can have 12, 13, 15 signatures and only 12 bodies in the classroom. So, well, but now it's fine. So how can we say that this is first and this is second? I don't want this first one here. So, how do you interpret Article 31 and Article 32? Well, maybe the question is too basic. What does it mean a treaty shall be interpreted, blah, 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 and Article 32 recourse may be had to supplementary means of interpretation, blah, blah, blah. Okay. Yeah. Let's say that an international tribunal has is facing a question of interpretation. Well, the international tribunal shall interpret the treaty in good faith, etc., in accordance with the ordinary meaning, etc. So it's an obligation to interpret the treaty. You have to act in good faith in accordance with the ordinary meaning, in the context, in the light of the object and purpose of the treaty. You have to do that. Okay, that's Article 31. That's the basic. That's what the basic rule of interpretation is made of. And Article 32, the option is not the same because Article 32 is just recourse may be had to. So it's maybe you don't have, it's not an obligation. You may have recourse to supplementary means of interpretation, including the preparatory works. You don't have the obligation to recourse to the preparatory works. The preparatory works, we've said, is the intentionalist school of interpretation, this one, okay? So it's to identify what was the intention of the negotiators, of the drafters of treaty. You don't have the obligation to have recourse to supplementary needs, to have recourse to the preparatory work. The interpreter may have recourse to those. It's not an obligation. It's not recourse shall be, etc., etc. It's only may. Okay, so clearly you have here the priority and here the secondary rule of interpretation. Okay, so in the case law of the International Court of Justice and of other international tribunals, we see that recourse to preparatory works can happen in two situations. The Article 32 states that the preparatory work of the treaty and the circumstances of its conclusion may be used in order to confirm the meaning resulting from the application of Article 31. So that's one option. Or to determine the meaning when the interpretation according to Article 31, okay, have it here, leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or unreasonable. So, here is an example. In what we call the Ambassador's case, before the International Court of Justice in 1952, the court said that in any case, whereas here, the text to be interpreted is clear, there is no occasion to resort to preparatory works. It means that if, by using the rules of interpretation that are incorporated within Article 31, you can identify the meaning of the provision. The court says we don't have to use preparatory works. Okay, that is once again clearly the recognition of the primary use of Article 31 and the only secondary use of Article 32. Well, it was in 1952, so it's not Article 31, Article 32, the rules codified in Article 31 and Article 32. Okay? So the court says, well, if I can understand the treaty by using the ordinary meaning of the term, then I don't have to resort to preparatory works. I don't have to use the preparatory works. The textualist approach to interpretation may be enough to understand the meaning of the treaty. We can see here an other expression, other situation in which the question of the preparatory works was presented to the court. So it's in the case regarding the sovereignty over Pulau Ligitan and Pulau Sipadan between Indonesia and Malaysia before the ICJ in 2002. So it's a delimitation dispute, delimitation litigation, and the court said that in view of the foregoing, the court does not consider it necessary to resort to supplementary means of interpretation, such as the travaux préparatoires, so it's in French in the judgment, even in the English version of the judgment. So travaux préparatoires, it means preparatory works. So the court does not consider it necessary to resort to supplementary means of interpretation, such as the travaux préparatoires of the 1891 Convention and the circumstances of its conclusion to determine the meaning of that convention. Okay, so that's the same as this. Okay, we don't need preparatory works. The court knows what the treaty means without referring or resorting to preparatory works. But the court also states that, or says that, however, as in other cases, it considers that it can have recourse to such supplementary means in order to seek a possible confirmation of its interpretation of the text of the convention. So, okay, so in that case, the International Court of Justice say, okay, with Article 31, I know what is the meaning of the treaty. I don't have the obligation to use the preparatory works, but I will use the preparatory works to confirm that the interpretation I conducted using the rules of interpretation of Article 31 is correct. Okay? It's just looking for the confirmation that of the correctness of the interpretation that has been conducted. So that is what Article 32 states here, in order to confirm the meaning resulting from the application of Article 31. Okay? So in that case, and the court, of course, has the right to use the preparatory works to confirm the correctness of the interpretation of the provision decided using the rules of interpretation of Article 31. Well, can you explain why the preparatory works are somewhat disfavored by international? Why states negotiating the Vienna Convention on the Law of Treaties decided not to see the preparatory works as a primary element to be to take into account primarily in the interpretation process? Why does the Vienna Convention only see the preparatory works as a secondary means of interpretation? You want to try something? Don't want to try? Well, the International Court of Justice says, yeah, when I know the meaning of the treaty, I don't have to resort to the preparatory works. Here, the International Court of Justice says, well, when I know the meaning of the treaty by using Article 31, I may use Article 32 only to confirm the correctness of my interpretation. It means that it's only secondary. But why this construction, this legal construction, is accepted by the states, and why states have decided to include in the Vienna Convention the idea that the ordinary meaning, etc., goes first, and the travaux préparatoires, the preparatory works, will only come second in the interpretation process. What could be the problem? What could be the problem if the preparatory works were to be considered as primary elements that every single interpreter has to take into account while processing to the interpretation?
I think in the preparatory work, the meaning are vague and it can be interpreted in a different way.
Yeah.
So if we take it into account and interpret by using the preparatory work, I think the meaning of the interpretation will be quite different from the original ordinary meaning in the convention.
Yeah, well, that's one point. It is true that if you if you want to use the preparatory works, it's quite easy to be selective.
Yeah.
And not to refer to all the preparatory works, and only to use the parts of the preparatory works that will be in favor of one state instead of another. So preparatory works can very easily be manipulated by the interpreter. So this is one of the reasons why the preparatory works are not seen in the Vienna Convention as something interpreters have to refer first or have to use first. But what could be the second or another explanation of this?
Because in the preparatory work, it consists of the arguments, the discussion, and in the preparatory work, it is not the agreed convention or laws yet. It is like people state the purpose of the law or the thing that they have proposed, but not the agreement. So we can refer to that just as secondary or supplementary resource.
Well, of course, in the preparatory works you have some discussions, but you also have some agreements. But I don't know if when negotiating the Vienna Convention. I'm pretty sure that when states negotiated the Vienna Convention, the question of what is the meaning of the ordinary meaning? What does it mean? What does it mean, ordinary meaning? Okay? Is it the definition of a term in the dictionary? And if so, which dictionary? Is it the definition of the term given by the Ministry of Foreign Affairs of any state, etc., etc.? So this was discussed by the negotiators of the Vienna Convention. But of course, before having the final draft of what will become Article 31.1, states may say, okay, we agree on the meaning of this expression, ordinary meaning. Is that during negotiations, you have some partial agreement, you have some agreements, and then you go and you can proceed to the negotiation, and every time you can have an agreement, you say, okay, we agree on that, let's move on to the next step of negotiation. And when you sign the treaty, well, you have all the agreements that you collected during the negotiation, and that will be the final draft of the treaty. So in the negotiations, you don't have only discussions, you also have agreements. And there may be in the negotiation of the treaty